Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. Learned counsel for the appellant has submitted that while awarding the compensation, tribunal committed an illegality in making only one-fourth deduction towards personal and living expenses of the deceased, and in not making deduction the amount of family pension. Learned counsel further submitted that from the FIR it is established that accident in question was a result of head-on collision of bus and motorcycle. Hence, in any case, the liability for making payment of compensation ought to have been apportioned, but the tribunal committed an illegality in not considering the same. Learned counsel further submitted that compensation awarded by the tribunal is excessive and exorbitant. The award therefore is liable to be modified. Per contra, learned counsel for the respondent's claimants has submitted that it is proved from the oral and documentary evidence adduced by the respondent claimant that accident in question had occurred on account of rash and negligent driving of the driver of the said offending bus. Deceased was not responsible for the accident in question. Learned counsel further submitted that impugned judgment and award passed by the tribunal is just and reasonable and therefore does not require any interference by this court. As such, this appeal is liable to be dismissed. Learned counsel for the claimant's respondents has further submitted that the matter in respect of permission to file the appeal under section 170 of the Motor Vehicles Act has been referred to the larger bench. He further submits that once the reference has been made to the larger bench, the question of obtaining the permission under section 170 of the Act is mandatory upon the appellant insurance company. If permission has not been granted, then the objection can be raised only on limited ground in regard to quantum. We have examined the argument of learned counsel for the claimant's respondents, and we find that points 3 to 5 have been referred to the larger bench, but they do not deal with the issue where the insurance company has been impleaded as a party and has contested the claim before the tribunal. If the insurance company has been impleaded as a party and had contested the claim before the tribunal, then the issue has been referred to the larger bench is not attracted. The present case is covered under para 8 of the aforesaid judgment, wherein the contingency has been dealt with, and therefore The argument of learned counsel for the claimant's respondents that the matter has been referred to the larger bench in regard to obtaining the permission under section 170 of the Act does not hold good, and the parties are to be governed by the finding recorded in para 8 of the judgment, which has become final, and the same has been recorded in respect of point 1 and draws distinction as compared to points 3 to 5, where the insurance company has not put in appearance and had not contested the claim. It is important to mention here that registration of FIR and filing of the charge sheet against the driver of the said offending bus are not in dispute. Thus, it is clear that adhere to the rule of equality in public employment is a basic feature of our Constitution, and since the rule of law is the core of our Constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirements of Article 14, read with Article 16 of the Constitution. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. If it is a contractual appointment, the appointment comes to an end at the end of the contract. If it were an engagement or appointment on daily wages or casual basis, the same would come to an end when it is discontinued. Similarly, a temporary employee could not claim to be made permanent on the expiry of his term of appointment. It has also to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the term of his appointment, he would not be entitled to be absorbed in regular service or made permanent merely on the strength of such continuance if the original appointment was not made by following a due process of selection as envisaged by the relevant rules. It is not open to the court to prevent regular recruitment at the instance of temporary employees whose period of employment has come to an end, or of ad hoc employees who, by the very nature of their appointment, do not acquire any right. High courts acting under Article 226 of the Constitution of India should not ordinarily issue directions for absorption, regularization, or permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme. Merely because an employee had continued under cover of an order of court which we have described as litigious employment, in the earlier part of the judgment, he would not be entitled to any right to be absorbed or made permanent in the service. In fact, in such cases, the High Court may not be justified in issuing interim directions, since, after all, if ultimately the employee approaching it is found entitled to relief, it may be possible for it to mold the relief in such a manner that ultimately no prejudice will be caused to him, whereas an interim direction to continue his employment would hold up the regular procedure for selection or impose on the state the burden of paying an employee who is really not required. The courts must be careful in ensuring that they do not interfere unduly with the economic arrangement of its affairs by the state or its instrumentalities, or lend themselves the instruments to facilitate the bypassing of the constitutional and statutory mandates.